On Tuesday, the opposition People's Progressive Party filed an appeal to the Caribbean Court of Justice seeking to challenge the ruling of the Court of Appeal's decision on Monday to honor only valid votes cast in the 2020 general and regional elections. An excerpt from the press release by the party read, "Moreover, the Court of Appeal in its pronouncement have plunged the law in total confusion, and it is now no longer clear how an election of members of the National Assembly is to be challenged and how the election of the President can be challenged. In fact, the Court of Appeal has wrongly ruled that these two challenges must be done separately and in different courts. To bring clarity to the law and to guard against the Court of Appeal wrongly giving itself jurisdiction, again, to either direct the Chief Elections Officer to submit a fraudulent and perverted report or to protect a fraudulent and perverted report submitted by the Chief Elections Officer to the Commission, we have decided to file an appeal to the Caribbean Court of Justice." In an interview with the Ghana Chronicle, which was broadcast via social media shortly after the ruling on Monday, the Attorney General, Basil Williams, asserted that the CCJ could not hear the case, and this is why.
Article 177.4 says quite clearly any decision made thereon was final, so that they couldn't appeal it. And equally, under our Caribbean Court of Appeal Act, Caribbean Court of Justice Act, Chapter 307, there's a provision also which says that the Caribbean Court will not exercise jurisdiction or hear any matter coming from our Court of Appeal, which was stated to be final also.
However, Leader of the Opposition and PPP General Secretary in a press conference on Monday said that the case is appealable to the CCJ.
We also argued that this is, and in fact we have made it public, that this decision on jurisdiction is appealable and may very well end up in the Caribbean Court of Justice.
Weighing in on the issue via a telephone conversation with this newscast on Tuesday, attorney-at-law Mayo Robertson, who had filed the appeal on behalf of his client, Eslyn David, stated that he's not surprised by the opposition's application, while also expressing the view that the Court of Appeal has the final say in the matter.
Keeping litigation going, so I can't say that I'm entirely surprised at the application, but I believe the law is very clear. Article 177.4 of the Constitution, under which we initiated this litigation, says in plain language that the decision of the court concerning any proceedings under that paragraph, that is 177.4, decision of the court shall be final. It is as clear and unambiguous as that.
Continuing with his argument that the CCJ has no jurisdiction to hear the matter, the attorney also had this to say.
And I believe further the Caribbean Court of Justice Act says, and I think it's Section 5, that no appeal would lie in those cases where local legislation says the decision of any court should be final.
March 2nd to June 23rd makes it 113 days since voters have cast their ballots at the general and regional elections, while uncertainty looms as to which party is the winner of the high-stake 2020 general and regional elections. Reporting for HGP Nightly News, Wendell Badree.